Okay.
There, you're a good-looking guy.
Good morning, Mr. Chairman, committee members. My name is Kenn. I'm a regional director with U.S. Term Limits. I live in Maine, and I want to thank you for this opportunity to testify in favor of this resolution. I would like to start my testimony by reading a quote by George Washington, because it's the basis of the rest of my testimony. And this is what he said. This had to do with the fight for ratification, and the quote is in regards to the anti-federalists who are trying to oppose the Constitution. And Washington said this, quote, "For their objections are better calculated to alarm the fears than to convince the judgment of their readers. They build them upon principles which do not exist in the Constitution, which the known and literal sense of it does not support them in. And this too, after being flatly told that they are treading on untenable ground, and after an appeal has been made to the letter and spirit thereof for reproof, and then as if the doctrine was incontrovertible, draw such consequences as are necessary to rouse the apprehensions of the ignorant and unthinking," unquote. The reason I share that is because I too used to believe in the myth of the Runaway Convention. In fact, I was so adamantly opposed to this thought of an Article 5 convention. Here in Maine, I had a DVD I would give my state legislators called Beware of Article 5, because I was getting my information from an organization instead of actually doing my own research. And what happened about 7 years ago, as I was opposing the Article 5 movement here in my state, it really forced me to do my own research and actually read what the framers wrote. So I went back to Madison's notes. I purchased the Federalist Papers, and lo and behold, I quickly realized that the Article 5 convention is not something to be fearful of. It's something that we need to embrace. And the idea of this runaway convention was nothing more than a made-up myth. And I'm going to prove that to you with the rest of my testimony. My written testimony, I hope you have that. I'm not going to go through each point here, but what I've done over the past 7 years, I have researched this along with others, and this is a compilation. I've created flashcards for you. If you can see these, on my second page here addresses each of the points. I made it very easy going back to the original sources, and I'd like to address a few of these. So the first one, the runaway myth. This is where it comes from. The story goes like this, and this is what I used to believe, that Congress called the Philadelphia Convention for the sole and express purpose to revise the Articles of Confederation. And what happened? The delegates arrived in Philadelphia, and within just a couple of weeks, they threw out the articles and drafted a whole new constitution. That is simply not true. That is not our history. The truth of the matter is this, is that the Philadelphia Convention was not called by Congress. It was called by the state of Virginia, and Virginia was responding to the Annapolis Convention of the previous year. And this is great history that really helps answer a lot of the concerns that I've heard this morning already. The Annapolis Convention was called to address trade and commerce issues. It was limited. All of these conventions of the states had been limited, and that's the whole process. And what happened there, not enough states arrived for a quorum. They could not conduct business. And they also realized once they gathered for those 4 days, in Madison, Hamilton, most of the framers were there, they realized that, listen, we have bigger problems in commerce. We need to address those. And they, in their report, I encourage you to read the Annapolis report, they said, because we do not have their credentials, the permission for the authority to go beyond commerce, we recommend next year that we meet in Philadelphia in May. And their recommendation was to devise as shall appear to them necessary to render the federal constitution adequate to the exigencies of the union. It was not to revise the articles. It was a full, broad call recommendation, which gave the delegations or the commissioners full authority to adopt a new constitution. That is what is the truth. Now, what happened was this. Virginia called the convention in October of 1786. It wasn't until 4 months later that Congress introduced, or should I say, offered their opinion. Congress had no authority under the Articles to even call a convention, but they did issue their opinion, and their opinion was to solely revise the Articles of Confederation. So that is where this myth begins. And James Madison specifically goes through both of those reports to prove beyond a shadow of a doubt that the convention did not exceed its authority. So once that straw man argument has been dispelled, all of your other questions are easily answered. In fact, on the very first day of the convention in Philadelphia, I hear people going around saying that, they didn't have their authority to do that. Well, the state that called it, Virginia, offered the 15 resolutions, the Virginia Plan, which was a different governing document. Immediately after that, Charles Pinckney, what I've done here, if you have this, I went through Madison's notes and documented every substantive discussion and vote on the amending provision. And he introduced a complete constitution on day one, and contained in that constitution was the amending provision, which clearly states that it is limited to the amendment by 2/3 of the legislatures that apply for it. I'd like to go on further here. Now, the framers, it was mentioned earlier by the sponsor that this is not a constitutional convention, and that is so true. The framers in their writings specifically talk about the two types of conventions. In fact, on September 15th at the Philadelphia Convention, a motion was made to give Article 5 the authority of a constitutional convention, and they voted that down. So they actually rejected the idea of Article 5 being a constitutional convention. In fact, James Madison, I'm sure you're getting a lot of emails from the opponents, and I want to share with you the tactics of these anti-constitutionalists today. What they do is they lift things out of context. And here's a perfect example. You might have heard that James Madison trembled at the thought of an Article 5 convention. And what they do is they lift a quote. I provided this in my testimony. This is the letter where they get the quote from. They will take the quote out of context and link it to the Article 5 convention. What they don't do is read the rest of the sentence, because within the very sentence, it talks about the Constitutional Convention. Madison was concerned about a second constitutional convention. That's what New York, the whole reference of his letter is addressing the effort by New York to call a second constitutional convention, not a Article 5 convention. And he specifically states the two types of conventions. A con requires unanimous consent to be called versus an Article 5, which is only 2/3. And if you read Madison's letter in context, you will clearly see that. So the opponents like to take and lift things to create a pretext, and that's what my research has given me the confidence that this cannot run away once we know more of our history. And I would like to just bring up to where we are today. John Dickinson at the Philadelphia Convention said, "Experience must be our only guide. Reason may mislead us." And I would say fear may paralyze us. And as I testify around the country, I do hear a lot of fear by state legislators about the process. And there's so much experience under these conventions. I just want to give you a few of these, but I do encourage you to look at these notes that I'm providing. Number one, the very first Article 5 application by the state of Virginia for the Bill of Rights was debated in 1789. Over 50 members of that first Congress were either ratifiers at their state conventions or delegates to the Philadelphia Convention. So I think they understood Article 5 pretty well. And if you read that debate, I provided that to you, you will see they understood Article 5 was limited. 2/3 had to concur on the amendment in order for that convention to be called. Our history with Article 5 applications, the reason that a convention has never been called, there's been over 400 applications submitted by the states to Congress. And the reason is because we've never reached the critical point of 2/3. That's why one has not been called, proving it is limited. 17 of our amendments have been in our current constitution was because of this effort by the states applying for those amendments. And so this process has prodded Congress to introduce the amendments that the states have requested. Now, we have a long, rich history of conventions of the states. And in fact, I've heard where this has never happened before. Well, it has happened before. We've actually had a convention of the states called to propose an amendment to the U.S. Constitution. When I learned about this history, it fascinated me. In 1861, it was the Washington Peace Conference. The state, again, Virginia, called it to try to prevent the Civil War from breaking out. 21 states sent commissioners to Washington, D.C. They met for 3 weeks, and they actually debated and passed an amendment to prevent the Civil War. Now, the only difference why this was not an Article 5 convention was because 2/3 of the states did not apply ahead of time. Just a handful did, I think 3. So what they did, they could not propose it out to the states for ratification. So John Tyler, the former president, he was the president at this convention. He delivered that amendment to Congress to have Congress propose it. Unfortunately, shortly thereafter, the war broke out. So we do have precedents on how this process works. Not only that, I think the greatest history that we have on this is the states themselves. There's been 233 state conventions to either adopt a new constitution or to propose amendments to their own state constitution. Out of those 233, there's been 146 constitutions adopted. I know North Dakota had one in 1972. I'm not sure if that was a constitutional convention to adopt a new one. I think it was. But also 6,000 amendments have been ratified, and they've been the product of these conventions. We know how it works. And what I would like to another fascinating bit of history is right now, you are currently involved in this process as a state legislature. There's an organization, or a body, I should say, that functions exactly as an Article 5 convention, and they've been meeting every year since 1892. The name of it is the National Conference of Commissioners on Uniform State Laws. It's known as the Uniform Law Commission. It operates just as an Article 5. The legislature, in fact, I looked at it last night. I have in my hands here Chapter 54-55 on how you appoint the commissioners to this body. The legislative management does it, and they are given credentials. They arrive at the limited, it's a limited scope of their meeting once a year. And in fact, right now, you have 5 of these acts currently in your legislature that were adopted at this convention. It's a conference convention, same terminology. And how it works is they vote by state. It's one state, one vote, as all of these conventions have been. Now, your commissioners, I think you have a couple legislators who are appointed to this commission, among others. They come back from that conference, and then they sponsor or find a sponsor for the Model Act, and I've listed the 5 that you are currently looking at. So we know how the rules work. You're using them every year, and this is something that the states have got to, the legislators need to realize, listen, we have the experience. We're doing it on an annual basis. This is something that we must use. This is critical to federalism. And just to give you a little last closing point here, Congress has introduced 12,000 amendments to the U.S. Constitution. 12,000. All this process does is, and the states have introduced 0 since 1789. It's 12,000 to 0. All this process does is give you, the state legislatures, the same opportunity that Congress has taken advantage of 12,000 times. In fact, last week I checked, already this year, there's been 24 amendments to the U.S. Constitution introduced in Congress. And in Congress, a single member can introduce an amendment on any subject they want. That's the runaway convention. But as you see, it's nothing to fear because it goes nowhere. Unfortunately, the bad news is a lot of these amendments are great reforms that our country needs, and our members of Congress, we can never get 2/3 of them to pass something that's needed. And that's why it's up to you. It is your duty and your responsibility to take charge and do the due diligence and use Article 5 as the framers intended. And so with that, I would like to just close and encourage you to please vote in favor of HCR 3033 and to show the world, and show the country that we can actually change our nation for the better by using the very Constitution and the tool the framers gave us. Thank you. If there's any questions, I'd be more than happy to answer them.